Good morning. Happy Monday. Really quick, I did the live stream twice about the Moore versus United States Postal Service. Today, BZ went into my comment section and said, actually, it's Moore versus Post Office 2005. Don't know what that is. I Google searched it, couldn't find anything. I think he's still just playing a game of pretending to be helpful while he's not being helpful, wasting everybody's time. I think I've beat that horse to death. E-Line was absolutely 100% clearly wrong. BZ is, I guess, still trying to simp for E-Line because E-Line gives him attention and pretends that BZ is an important person. Whatever, I don't know what's going on with that, but I guess you find your friends as you can, right? So if BZ is the kind of guy that E-Line needs to suck up to now, well, it kind of belies the idea that E-Line is a civil rights activist who is writing legislation. If he has to hang out with BZ, if that's the kind of guy who has to get on his show, think about all the other political channels that get actual guests on and not a fat Uber driver who doesn't know shit about fuck. So there's your sign. Now he said this, E-Line said this in a live stream where he was talking about why won't a attorney take your case? And he said that he wouldn't sometimes return to people's phone calls because he's a civil rights activist and he's busy writing legislation, which is absolute and utter nonsense. But it's really easy to figure out why an attorney won't take your case. Assuming that you are a plaintiff suing the government. Remember, there's three things you got to prove. Number one, you have to prove that they did a bad. Number two, you have to prove that you were injured by the bad that they did. And number three, you have to be able to recover. That's it. That's what you got to do to get an attorney to take your case on contingency. You have to show they did a bad. Specifically, you have to show they did a bad that you can recover from, like something that you could sue under the Federal Tort Claims Act or the Government Tort Claims Act if you're in state or federal court. Or 1983 liability. There has to be some sort of a cause of action. They have to do a bad that there is a cause of action for. You have to be injured by it, and they have to be able to recover. If you hit those three notes, then an attorney will take your case on contingency, most likely, because the government's going to pay. And especially if it's a 1983 lawsuit, then there's a attorney fee provision, 42 U.S.C., I think 1988 or 1985, I forget which one it is, but there's an attorney fee provision, so, you got that going for you. If you walk in, you want to sue the government, the attorney says, I'll only do it on a flat fee basis or on a hourly basis, you know that you have a real problem. The government can pay. So the question is, why won't the attorney do it on contingency? And that's probably because either there is a question on whether or not you have a valid cause of action, either there's a problem with what the government did isn't a bad, or there's no theory of recovery for it, like you can't sue them for it. Or less likely, it could be that you weren't damaged, but that's less likely. Most likely, if the attorney's not taking it on contingency, but he will take it on hourly or flat fee basis, it's most likely because either it's questionable as to whether or not there's a theory of recovery, or it's questionable as to whether or not the government did a bad. One of those two things, okay? And if an attorney says he won't take the case at all, even if you pay him, well, attorneys are doing this to make money. This is how attorneys make their living. Carpenters make their money working with wood. Lawyers make their money working with words, working with lawsuits. This is how we make our money. When a client walks through the door, the first thing that the lawyer thinks about or should think about is, how do I make money? Yes, it will be by helping the client, but how do I make money? Because I have to feed myself. I have to pay my rent on my law office. I have to pay my phone bill for my law office. I have to pay for my law license. I have to pay for access to LexisNexis and all these other things. I have to pay. So an attorney is going to think, how can I make money off this? And if you walk through the door and the attorney just says no, then there's a problem there. And that problem has to be significant enough that the attorney is saying, I don't want to risk my law license and face potential sanctions by representing you. Now, attorneys can sometimes fluff you up by saying, well, I would totally take your case, but I'm just too jammed, too busy with other clients right now. What he's really saying there is that, well, either he has clients where there is a better likelihood of recovery, or a better likelihood of a larger recovery, or he's just being nice and saying, well, you don't have a case. That's why attorneys won't take your case. Remember, we do this for a living. We do this to make money. If we're saying, no, I won't do it, not even on an hourly basis, it's because there's a real problem. There's a real problem. If we do it on an hour, we do it, but we say we'll only do it on an hourly basis or a flat fee basis, it's because there's a problem. There is a problem, but it's not that bad. I mean, there's a chance. You still have a chance. I'm not saying it's a good chance. If there's a good chance, we do it on contingency, but you still have a chance. And if we do it on contingency, that means that there's a really good chance. As an attorney, I've done the calculations in my head. You're more likely to hire me if you don't have to pay money up front. I'll get a little bit more on the back end, hopefully, if things work well. I'll get, maybe up to half of the recovery. And if it's a substantial recovery, that's great. Maybe a third, maybe a half, somewhere in there, right? I take the risk with you, and you don't have to pay me until it's done. So it works out well for everybody. And so if there's a good case, I do the math. I'm like, I can make this much money if I do a contingency. I'll be like, yeah, I'll do it on contingency. Or if you really want to pay me up front, I'll do it by hourly too. I mean, I'll get paid either way at that point. I'm guaranteed income on the hourly. I'm less guaranteed income on the contingency, but I have the opportunity to make more is really it. So that's the calculus attorneys use. If the attorney's not taking your case, there's a real problem with it. Anyway, that's all I got for you. Thanks for watching. Have a great day.